Call this hearing of the Judiciary, Finance, and Civil Law Committee to order. Today is January 19th, 2023. We do have a quorum, so the first thing on the agenda will be the minutes. Representative Carroll, do we have a motion to move the minutes?
So moved.
All right, Representative Carroll moves the minutes. Any discussion? All those in favor, please say aye.
Aye.
Aye. Opposed? The motion prevails. The minutes are approved. So first on the agenda today is House File 4. As members remember, we did hear this last week, but due to some discussion and wanted to make sure we get this right and that this committee is the one to address the data issues that are in this bill. We've got it back in front of us. So I will move that House File 4 be recommended to be referred to the Committee on Ways and Means. Representative Gomez and Perez Vega. You've got an author's amendment. So I will move the A21 amendment. Representative Gomez, please tell us about your amendment.
Good morning, Chair Becker-Finn, members of the committee. Judiciary and Civil Law treated us so nice we had to come back to visit you again. Basically, after we passed the amendment, it was a week ago, it came to our attention that there were some issues that needed to be addressed from Driver and Vehicle Services, and so I just want to thank your nonpartisan staff for working really hard on this. Thank you so much, Mr. Hopkins, for your assistance. And Representative Scott has been involved in these conversations. And if you don't mind, I would love to ask Mr. Hopkins to walk through the A21 instead of doing it myself, if that's okay.
That's why he's here. All right, Mr. Hopkins.
Madam Chair and members, so the A21 amendment, I'll go through it line by line and kind of try to summarize it briefly for the committee. So you can see this is all going to affect Article 2 of the second engrossment of the bill, which deals with data protections. At 1.2 of the amendment, it's deleting the current Section 2 of Article 2, so it's getting rid of that 14-day data destruction requirement. Then it adds some new sections. The first section you see requires subscribers to the driver's license data subscription services to include information about compliance with the certification requirement in their audits. The next section that's added, you can see the new language at 1.16 of the amendments. This also adds a cross-reference to that requirement for certification for when someone requests data on non-compliant licenses. At the bottom of page 2 of the amendment, most of these changes are to that certification requirements. And one thing that it does is it makes clear that a data requester, it changes the term person to data requester, so we know that the data that could mean a government entity, it could mean a non-natural person or a natural person, i.e. a human being. And the real meat of the amendment is on page 3 of the amendment, and this is giving us a new subdivision 11, which is the primary data practices subdivision for this bill. Paragraph A, there on page 3, starting on line 5, gives a definition of immigration status data. So this is data on non-compliant license holders that will indicate their immigration or lawful presence status. The paragraph B classifies immigration status data as private data on individuals and says that it should not be shared outside of the division that administers driver's licenses, but it may be shared with the Secretary of State for purposes of improving voter registration records. The new paragraph C, starting on 3.19, this allows dissemination and sharing of non-compliant license data that is not immigration status data. So data on non-compliant license holders, which does not indicate anything about lawful presence or immigration status. That allows data sharing that's otherwise authorized by state or federal law, but it provides that that information cannot be used for any civil immigration enforcement purposes or disclosed to any federal government entity that enforces immigration law. Paragraph D, starting on 3.27, this prohibits any data sharing between the Department of Public Safety, which administers the driver's licenses, or a driver's license agent, and a federal government entity that enforces immigration law. So immigration status data or any other data on non-compliant license holder can't be shared to federal government entities that enforce immigration law. And then paragraph E just clarifies that a violation of this subdivision here could give rise to penalties and remedies under the Data Practices Act. Madam Chair, that's it for the amendment.
All right, thank you, Mr. Hopkins. Anything further you want to say about the amendment, Representative Gomez or Representative Perez-Vega?
No, I think they kind of covered it. I think that, you know, on the third page, that paragraph C just allows DVS to share the data that they need to share and that they are accustomed to sharing about non-compliant licenses. And so I think that was sort of the concern that we were trying to address.
Sounds good. Any discussion to the amendment? Representative Scott.
Thank you, Madam Chair. And I had some very spur of the moment and rather lengthy conversations yesterday with folks from the Secretary of State, and I'm wondering if they could come forward so I could just get a couple things on the record from those conversations. So while she's coming down here, we're having discussions with them at DPS as to how this sharing of data actually happens in practicality. And so I'm just wondering if our testifier from the Secretary of State's office could kind of walk through for the committee so they have an understanding of how that works and how this amendment will practically play out. Thanks, Madam
Please
Chair.
introduce yourself for the record and go ahead.
Julie Strother, opposite the Secretary of State. So right now we get two files. One is a daily file on those who are registering at the time of getting a license, and one is a monthly file of non-citizens who have a driver's license. And my understanding, DVS can verify, but this would allow us to keep getting that data that we need to keep our voter records as clean and as accurate as possible.
Representative Scott.
Thank you, Chair Becker-Finn. And Ms. Strother, right? Yeah, thank you. And so in our conversations yesterday, we talked about whether all of that was still doable, and we came to the conclusion that it is. And I do have one question that I didn't ask because I talked to a county commissioner last night, and they actually were saying that there's nothing explicitly in statute that says that the Secretary of State has to update the rolls on people, on data that they get from the health department when people pass away. So I'm wondering if there is anything in statute currently that requires the Secretary of State to update the voter rolls in this regard. Is that your responsibility in statute? Is it the county? Is it clear? If you could answer that question, thank you.
Ms. Strother, remembering that, trying to keep to this amendment in this bill, but go ahead.
Yeah, Madam Chair, Representative, so under statute, and I believe it's 201.145, and I'm hoping that someone with the statute book in front of me can check that for me, but there is a section of statute about how we deal with data from other agencies, and we are required to, with DVS data in particular, match that data against the voter registration system, send those exact matches or potential matches, in this case on potential non-citizens, to the counties. It's the county's job, and they have a statutory obligation to review that data if there appears to be a match, to put a challenge on the voter record, and then send it to a county attorney for further investigation. So it's our obligation to do the matching and take in that data in the system. It's the county's obligation because we don't update voter registration records, but we provide the data to the counties who have an obligation to then update that.
Thank you, Madam
Scott. Any further discussion to the A21 amendment? And thank you, Ms. Strother. All right, seeing no further discussion, I will renew my motion to adopt the A21 amendment. All those in favor? Aye. Opposed? The motion prevails, the amendment is adopted. So with that, since we've already had a full House File 4 hearing, we will go ahead and vote on House File 4 as amended again. So I would renew my motion that House File 4 as amended be recommended to be referred to the Committee on Ways and Means. All those in favor, please say aye. Aye. Opposed?
No.
The motion prevails. Thank you for coming back again at 8:30 in the morning. We're having some technical difficulties, but we're learning what fun sounds our government-issued computers are capable of, so.
Sounds like an arcade.
Madam Speaker.
Chair, but yes.
Madam Chair, sorry. Question, I'm having trouble hearing when testifiers are at that far microphone, so while we're waiting for the next bill, I don't know if there's a way to adjust that or just make sure that the testifiers pull it down closer.
Our pages are checking into it. Thank you.
Madam Chair.
So next up on the agenda is House File 100. I don't see Representative Stephenson yet. So I'm going to go ahead and move House File 100 and hope that he is in the elevator and yeah, we'll teach people what happens when you're not here for your bill. I think a lot of folks who looked at the calendar today saw House File 4 and didn't realize that we'd already heard the bill. So we're thinking there was more to do, but we already did all that work. So good job, everybody. Do we have somebody from nonpartisan here? Oh yeah, you're the cannabis guy. I forgot, Ben. All right. So I will move House File 100 be recommended to be referred to the Environment and Natural Resources Finance and Policy Committee. I understand there's an A10 amendment. Mr. Johnson, would you explain the A10 amendment?
I can, Madam Chair, just one second. Madam Chair, members, the A10 amendment makes a variety of changes throughout the bill. One significant change that it does is it adds cannabidiol, which is CBG, as a non-intoxicating cannabinoid in most of the locations where CBD, cannabidiol, currently appears. It also conforms the list of products that can be used as medical cannabis products to the list that the Minnesota Department of Health has actually approved. In current statute, there is a list, but there is also authorization for the Commissioner of Health to add delivery methods to that list. The Commissioner has done so. The amendments that are in this would conform statute to what has actually been approved by the Department of Health at this point. The same is true for the qualifying medical conditions. So for example, page 1, line 12 adds Alzheimer's, and there are a few other conditions that are added. Similarly, there is a list in statute right now, but the Commissioner has the authority to expand that list. The Commissioner has done so. The additions in this amendment would conform what is in statute to what is the real list, if you will, that is currently approved by the Department of Health. There are a few technical changes throughout, changing the term commissioner to office. That was a drafting error that is my responsibility. The commissioner is no longer making these decisions because it refers to Commissioner of Health. Again, many of the Department of Health statutes related to the medical program have been moved over, and so there are just technical corrections changing commissioner to office. At page 2, line 18, there is a change to some data classification. The current bill language refers to data essentially on individuals. It is true that some of this data is on individuals and some of it is not on individuals. The change here just clarifies that the data would be non-public. There are two different definitions, one that applies to individuals and one that applies to businesses and others. This just makes it clear that both of those definitions would apply. Page 2, line 21, that is another drafting error that's corrected. It should have referred to a different license category. There's a second place in the list where the delivery methods are mentioned. And again, the changes in this would just conform to current practice right now. On page 3, You can see changes at lines 8 and 9 that refer to professional capacity or as a patient. There are protections for various entities involved in the medical program, in setting up and establishing the medical program and monitoring it. And there are protections in statute now for those people. This just clarifies that those protections apply. It's essentially licensing protections for doctors and other professionals. The protections would apply to participation in the medical program, either in a professional capacity overseeing it or as a patient enrolled in the program. Moving down to page 3, line 18, the other changes that I'm skipping over are changes that are identical to ones I've already mentioned. In the medical program right now, there is a protection for attorneys for their attorney license related to counseling medical businesses. This pulls that protection out of the medical only and would insert it and apply it to all businesses, meaning an attorney would be able to counsel any prospective or current cannabis business, and this would offer protection saying that the Supreme Court could not take action on their license. And the final change is starts on page 3, line 23. This adds a reference to first-degree possession of marijuana. It deletes a section referring to a number of plants. This, again, was a drafting error on my part that was intended to be removed initially. Madam Chair, I think that covers all of the provisions that are in the amendment.
Thank you, Mr. Johnson, and no shade on catching some drafting errors. Appreciate your honesty with some of those updates. Welcome, Representative Stephenson. We have a lot of work to do, so we just went over your amendment. The amendment's now before us, the A10. Anything else you want to say about the A10 amendment?
Thank you so much to Ben Johnson for everything, who is a great rock star in this legislature.
Yes, we ask a lot of our staff, and we have some good ones on this committee. All right, any other discussion to the A10? Representative Feist.
Thank you, Madam Chair. I was just curious about the provision around attorney disciplinary action. Is the reason for that because we can't control what federal law makes criminal?
Representative Stephenson.
Madam Chair, Representative Feist, exactly.
Okay, thanks.
All right, great. Moving on to the A10, all those in favor of adopting the A10 amendment, please say aye. 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 Opposed? The motion prevails. The amendment is adopted. I believe, Representative Stephenson, the bill is now in the shape you would like it. So we do have quite a few testifiers, but want to let you give us an intro to the bill.
I know that thank you, Madam Chair. I know the committee has a lot of work this morning, so I'll just be very brief. I think most members know this is the bill to legalize adult use cannabis in Minnesota. Minnesotans are ready for this change. The current laws are doing more harm than good. I appreciate this committee's attention to the very important issues in the bill that relates to this committee's jurisdiction, and look forward to a good conversation about that today.
All right, sounds good. Well, we will get to testifiers. I've got Marcy Exted. And then Jess Hauser on deck.
How does it sound? Can you hear me okay?
I guess so. Is that better? Representative Mueller? Oh, apparently we don't have control over it. So, but somebody somewhere knows that we complained about it now. So.
Well, I'll try to project too.
Perfect.
Yeah, perfect. Thank you for having me today. Yeah.
Yeah, why don't you try sitting since no one else is using that mic? Maybe that one was a little bit better. And then just introduce yourself and then go ahead with your testimony. Thank you.
Better?
Better.
Cool. All right, I'm Marcy Exted, and I work for the Urban League Twin Cities at the Center for Social Justice Research, Policy, and Advocacy. I'm a research associate there, and I also chair the Social and Restorative Justice Policy Task Force for the Great Rise, and I also do contract work for the Minnesota Justice Research Center on a project where we're trying to understand community members' experiences with cash bail in Hennepin County. So I'm really here to come before you today with 4 kind of explicit requests for this bill, particularly as relates to bringing equitable and just outcomes for Black folks in our community, as well as other folks in our community that have been most harmed by cannabis prohibition. First, I wanted to call on leadership to consider a focus completely on a pardon system rather than expungement. People harmed by cannabis prohibition deserve to have their records completely erased, and an expansion of the range of offenses that would be pardoned if available. Second, I ask that we remember our youth in Minnesota. According to the Sentencing Project in 2019 in Minnesota, Indigenous youth were nearly 12 times, Black youth nearly 8 times, and Latina youth 2.7 times more likely to face juvenile detention compared to white students. And currently, this bill kind of continues to just fuel a prison to school to prison pipeline. And I would really like us to directly address that and provide supports for kids rather than arresting them for cannabis use and possession. Having them experience the trauma that comes with impacts of the carceral system and arrest experiences. Third, I also ask that we remember our immigrant neighbors. If we only focus on expungement as is in the current bill language, we actually risk people continuing to be facing deportation or being barred from obtaining citizenship because they can't access their documentation with sealed expungement and the record is still accessible to certain entities. Finally, I ask that there be a mechanism built into the process and the bill language so that the public can track how many records have been processed and how many are currently being processed in near real time to center transparency and accountability. Thank you.
All right, thank you for your testimony. Next on the list, I have Ms. Jess Hauser. I've got Munira Mohammed on deck, so if you want to make sure you're close at hand, that would be great.
Thank you, Madam Chair.
Yeah, please introduce yourself and go ahead.
Yep, my name is Jessica Hauser. I'm representing Sensible Change Minnesota today in this testimony. Sensible Change Minnesota is a spinoff of Sensible Minnesota, a 501c3 nonprofit organization founded in early 2015 that ran a patient advocacy program through mid-2020. During those 5 years, we had dozens of patients reach out about discrimination by landlords and employers that cost patients their homes and livelihood for simply using medicine approved by their healthcare provider. Employers and landlords often fall back on federal law as justification, which any employer or landlord could do under the current language, even if it had no effect on their business operations. It was assumed that the employer or landlord must also seek to lose federal benefits, but that is not how the statute is written. Suggestion is to switch out or to ensure we are better protecting patients. This is a top priority for our organization as we are very focused on patient and consumer protections. We are very supportive of this bill and looking forward to continue to work with Representative Stephenson. I'm here on behalf of our policy director, so I don't have as much experience as to the detail of the language of the bill, but wanted to represent our organization and let you know that we are supportive of this bill and look forward to it providing additional patient protections and consumer protections. Thank you.
Thank you for your testimony. Munira Mohammed, please introduce yourself and go ahead with your testimony.
Hello, and thank you to the chair and members of the Judiciary Committee. My name is Munira Mohammed, and I'm on the policy team for the American Civil Liberties Union. That's the ACLU. The ACLU is a longstanding organization devoted to preserving individual liberties enshrined in our Constitution and our laws. The ACLU Minnesota is in support of House File 100. Cannabis laws desperately need reform due to the stark racial disparities in marijuana possession arrest and the fact that they haven't gotten better in Minneapolis or in Minnesota nationwide. Nationally, on average, a Black person is 3.6 times more likely to be arrested for marijuana possession than a white person, even though Black and white people use marijuana at similar rates. Here in Minnesota, it's an even bigger problem. A Black person is 5.4 times more likely to be arrested than a white person, which is significantly worse than the national average. The disproportionate targeting and over-policing of Black communities for substance abuse that is equally used among the population
is a logical consequence of marijuana criminalization and the byproduct of the failed war on drugs. Being caught with even the smallest amount of marijuana can risk your housing status, employment opportunities, child custody determinations, immigration status, and the eligibility for financial aid. It can ruin lives. House File 100 is a viable path towards responsibly legalizing marijuana use and the possession for Minnesota adults. It has strong provisions that don't simply replace marijuana prohibition with onerous fines and fees that can disproportionately affect marginalized families. It also provides clemency or resentencing for certain marijuana convictions and expungement of past marijuana convictions. We sincerely hope the legislature takes quick and serious action on moving this forward. Full legalization would stop further arrests for possession, decrease prison populations, reduce the criminalization of Black and Brown communities in our legal system and in Minnesota. ACLU Minnesota urges you to support House File 100. Thank you to the chair and members.
All right, thank you. Moving on to public testimony. First up, I have Rich Neumeister. And we do have a very long list, so we're going to be timing folks similar to what we've done in the past. And I know our committee administrator has notified people of that ahead of time.
I even have a timer right in front of me. So.
All right. All right. Please introduce yourself and go ahead with your testimony.
Good morning. My name is Rich Neumeister. The lack of public data accessible on the applicant licensing in this bill for the public to keep in check this $500 million industry is not good. It's abysmal. In other states with legalization of marijuana, there has been favoritism, conflict of interest, and corruption in the licensing and cannabis business. News media and public groups have been able to use their public data accessible to them to expose and bring sunshine, that nice disinfectant. Make sure that those things don't happen. Or if it is happening, to expose it. Now, by making certain data available about the cannabis industry to the public, it removes a layer of secrecy and gains trust in Minnesotans. Now, MinCoG has before you, at the request of Representative Stephenson, and a lot of folks have been put input into it, me being one. I'm not with MinCoG. In the bill, there's what is called, what MinCoG is suggesting should be public, and then things that should not be public. Well, a clean way to do this is, in most things with data practices, as some of you, if you've read those packets that the chair encouraged you to read, you know the presumption of all data is public unless there's a classification. So the suggestion is, from at least what MinCoG and I agree, that take what should be not public, make a straight, clean classification, and we'll all know we'll have transparency and accountability. I got a real quick email from someone who knew I was saying, he wants to make sure that the scoring of the
Mr. Neumeister, I don't know if maybe you set your timer for a different amount of time. So, but
anyway,
as folks know, I try to keep it fair for everybody.
Those
So
points have been made directly, and I would like to thank Representative Stephenson for his open door and his continuing openness to work on this issue.
thank you.
Thank you.
Mr. Thomas Evanstead. I've got Sheriff Torgerson on deck. Please introduce yourself for the record and go ahead with your testimony.
Thank you. Good morning, Madam Chair and members of the committee. My name is Thomas Evanstad, E-V-E-N-S-T-A-D, and I'm with Public Safety Minnesota, and I testify today in support of this bill. On September 6, 1988, U.S. Administrative Law Judge Francis Young declared marijuana in its natural form is one of the safest therapeutic substances known to man. Quoting him, "No human in 5,000 years of consuming cannabis has fatally overdosed. It is impossible to consume enough cannabis to kill even the animals they've tested to determine cannabis's lethality." The empirical evidence from rec legal states citing NORML's research is that the highways and roads are not more dangerous post-legalization, but rather the opposite. Most experts, including myself, attribute the reduction in DUI-related deaths to increased cannabis and reduced alcohol consumption for drivers on the roads in states that have legalized cannabis. Many recreational users like myself choose to consume cannabis instead of alcohol after experiencing the damage that alcohol causes as opposed to the health benefits of cannabis. I urge the bill's authors to add the Illinois provision prohibiting law enforcement from using the quote, "I smell weed," unquote, ruse that allows them to toss anyone's vehicle, whether they actually smell weed or not. For the confiscation seizure gravy train they've enjoyed forever and are fighting so hard to keep. This bill will not address racial disparity or profiling without it. SB 2939 is the legislation amending the Illinois Vehicle Code. Finally, law enforcement, in my opinion at least, should be focusing on the public safety crisis that has violent, domestic, and especially gang criminals killing people every day, not
Ms.
cannabis.
Instead, I'm going to have to ask you to wrap up.
Never killed anyone. Thank you, Madam, and thank you, members of the committee.
Thank you. Sheriff Torgerson. And then I've got Chief Jay Henthorn on deck.
Morning, Madam Chair.
Welcome to the committee. Please introduce yourself and go ahead.
Committee members, I'm Kevin Torgerson, the Olmsted County Sheriff. For nearly 20 years, we have cut our number of fatalities on our roads nearly in half with the advent of recreational marijuana in other states. The number of fatalities has increased where one or more drivers was marijuana impaired. By passing this bill, the loss of life on our highways will be collateral damage in favor of those who wish to put a foreign substance in their body. Just recently, the Minnesota Poison Control Center noted the significant increase in emergency room visits of children ages 0 to 5 had consumed infused edibles. It has been stated repeatedly that marijuana is safe and is not a gateway drug. Yet treatment centers continue to advise of clients who started their addiction path with marijuana. The entire section of 152.0263 should be assessed with lower weights. This is not your father or grandfather's marijuana that was grown in the ditch. No one needs that much marijuana in their home or on the street for personal use and, God forbid, youth access. We feel the penalty rewrite should be more significant for possession and sales in sensitive areas. In lines 154.14 to 154.17 are struck and moved to a gross misdemeanor level. This should be a felony in those sensitive areas. Most of the bill indicates effective dates on August 23 or January of 24. In Article 4, this bill authorizes an oral preliminary test pilot project between August of 23 through July of 25. I ask you to delay activation, giving us the time to run the pilot project before full legalization. We also need time to train drug recognition experts and new canine drug detection dogs.
Sheriff, I'm going to have to ask you.
These types of trainings don't happen overnight. I am done. Thank you, Chair. 90 seconds is nowhere near enough time. It's very disappointing.
It is what it is. Well, tempting to defer to the those in uniform getting more time, trying to treat everybody with equal equal judgment. The clock is the clock. And just so the public knows too, all these testifiers were told ahead of time that this is how much time we had. The other option we have is that fewer people get to speak. And so the choice that I've made is I'd rather have more people have the opportunity to speak, but then we've got to limit time. And that's just the reality of 24 hours in the day. I did not start your clock yet. So
I appreciate that.
So
because I thought I was going to have to go as fast.
Yeah, no, that's fine. So thank you very much for being here. Please introduce yourself and go ahead with your testimony.
Good morning, Madam Chair, Becker Finn, and committee members. My name is Jay Henthorn. I'm the Director of Public Safety and Chief of Police for the City of Richfield. I'm here today to testify with concerns on House File 100 as it is currently drafted on behalf of the Minnesota Chiefs of Police Association. Our association collectively represents over 300 police chiefs from across the state of Minnesota. As the legislature debates the legalization of adult use cannabis, it is important to remember that local governments and local law enforcement will be on the other end of the law you ultimately pass. It is important to prioritize a tight legal market and regulatory structure to not increase an existing illicit market. Unfortunately, this bill does not do that for a variety of reasons that are within this committee's jurisdiction. The significant amount of cannabis an individual can legally possess and grow at their home is one reason. This will not enforce a tight regulatory structure through the consistent retail outlets. This will lead to more work for law enforcement and only further an already flourishing illicit market. In Section 9 of House File, the bill doesn't allow for the use of cannabis while operating a motor vehicle. While this is an important prohibition, it is completely unenforceable as there is no commercially viable roadside test at this time. Because of the lack of tests and the complications around it, the prohibition could be strengthened with a zero-tolerance policy that other states have passed and possibly prevent negative interactions with law enforcement. Our association will have other concerns for the Public Safety Committee, but we are willing to work with anyone at the legislature on this issue through the process and thank the committee for their time and consideration. Thank you.
Thank you very much for your testimony. Next up, I've got Rihanna Buchholz. And then on deck, I've got Rob Dorr.
I've tried practicing my timing, so we'll see.
All right, please introduce yourself and go ahead.
Thank you, Madam Chair and members of the committee. My name is Rihanna Buchholz, and I am the Legislative and Coalitions Director for Americans for Prosperity here in Minnesota. AFP believes in a dignified approach to public policy, advocating for bottom-up solutions that help every individual achieve their potential. We also strongly believe in second chances and empowering individuals to use their experiences to make a positive impact for themselves and their community. House File 100 is a great example of a transformational measure that will help right long overdue wrongs of the war on drugs and uphold constitutional rights for individuals impacted by prohibition. While we enthusiastically support the expungement measures, we also believe that the bill could go farther in removing barriers for those with past low-risk criminal records. For example, rather than barring large classes of individuals with various types of criminal records, we prefer a more tailored approach for those who pose a unique risk, such as diverting legal products to the illicit market that we still expect will exist sometime after legalization. We'd also like to see some of the criminal penalties in the bill be changed to civil penalties. It's our opinion that these well-intended provisions should not create additional barriers while embracing a new industry. It's our hope that dismantling cannabis prohibition will help reduce the number of individuals who encounter the judicial system and not be plagued with criminal records that could hinder their opportunities. We thank Representative Stephenson for shepherding this legislation through and taking into consideration all of the various stakeholders and individuals impacted by this bill. Thank you.
Very good. It was just starting to beep at us. So thank you for your testimony, Mr. Dorr, and then I've got John Barty on deck.
Thank you, Madam Chair, members of the committee. I'm Rob Dorr. I'm the Vice President of the Minnesota Gun Owners Caucus. The Minnesota Gun Owners Caucus doesn't take a position on the legalization of cannabis, but we do believe that those who partake of legal products, whether through the medical or recreational arena, should not lose their constitutional rights for having done so. We greatly appreciate Representative Stephenson's efforts to preserve the Second Amendment rights of people who are participating in these legal, what would be legal underneath this. Those of you who are returning to the legislature may recall that your former colleague, Representative Hamilton, lost his Second Amendment rights merely by just by participating in the program prior to even filling a prescription. So we don't believe that gun owners should be penalized. Relevant to your jurisdiction in this committee, we would like to work with the author to see that the expungement provisions would create a presumption that somebody would have their rights restored rather than need to justify that their rights get restored. These are people who, by the nature of the expungements, did not involve a dangerous weapon or the infliction of bodily harm, yet lines 173 and 170, on pages 173, line 18 and 172 line 8, it creates the presumption that you don't get your rights back unless the Cannabis Expungement Board determines there is good cause. We'd like to see that flipped, that if we are expunging people, that they are getting the full birth of their constitutional rights back.
Well done, sir. John Barty. And then I've got Alex Hassel on deck. Welcome to the committee. Please introduce yourself and go ahead.
I'm John Barty. I'm representing Uniflora Holistics, a Minnesota cannabis company. Today I just wanted to talk to you guys about remembering that this industry is already a billion-dollar industry. that there are people in Minnesota right now who consume cannabis and sell cannabis, and a lot of those people will be the ones we rely on to make this industry work once this bill goes through. These people right now are being criminalized for consuming and selling cannabis, and with this bill legalization, we are officially recognizing that that is wrong. So we need to make sure that this bill it can't completely go back and change everything that's happened, but it can be a accelerator for a better future. So I believe that we need to raise the floors on the civil and criminal penalties in the bill so that people can be raised out of criminalization. Like right now, it is still, like I agreed with one of the officers here. He said it doesn't do what it's meant to do, which is stop the illicit market. That's what we're all trying to do, is end the illicit market. Make sure that everything that happens with cannabis happens legally. And the way the bill is written right now, it will not stop those who want to come to the legal market from it won't help them switch over to the legal market. Sorry. Thank you.
Yeah, thank you for your testimony. Alex Hassel, and then I've got Marcus Harkis on deck.
Thank you, Madam Chair and members of the committee. My name is Alex Hassel, and I'm here on behalf of the League of Minnesota Cities. I'll be brief because I want to respect the jurisdiction of this committee, but our comments on these sections really connect to the larger need for a partnership between the state and cities regarding the regulation and oversight of some of these pieces. Article 1 in particular speaks to the inspections the state would conduct under this bill. We are glad to see that the state will be taking an active role in this, but would also like to see the authority for local law enforcement to conduct compliance checks for retailers. Checking compliance statewide will be a huge task for this new board, and to make sure that these checks happen, it's important to include local governments in that process. As used for liquor and tobacco, compliance checks are an important tool to ensure that retailers are acting in accordance with the law and not selling products to those who are under the legal age. While certainly not all retailers are bad actors, some unfortunately do fail to maintain compliance. These checks allow licensing authorities to ensure that they provide licenses to responsible retailers that do not have a record of noncompliance. This is just one example of where local governments fit into this discussion. As you heard from law enforcement, there are impacts to public safety and time and resources that law enforcement will need to spend on this issue, which we hope the committee considers. Much of this fits into the broader conversation of what role cities should play in terms of licensing, but I'll leave that for another committee. I'd like to thank the author, Representative Stephenson, for his willingness to work with us on this issue, and we look forward to continuing that work. So I'll leave it at that for the sake of brevity, but thank you for the opportunity to testify.
Thank you very much for your testimony. Marcus Harkis, and then I've got Vina Iyer on deck. Please introduce yourself and proceed with your testimony.
Good morning. My name is Marcus Harkis. I'm with Uniflora Holistics, a Minnesota cannabis company. I'm here in favor of full legalization and ask the representatives to help us make House File 100 a truly just and equitable cannabis legalization bill. I began smoking cannabis daily at the age of 20 after experiencing excessive racial profiling and police brutality in the Twin Cities. And I also experienced a couple of traumatic incidents of unjust police brutality. Once over the smell of cannabis by a female U of M cop who verbally and emotionally abused me for an hour, and sexually assaulted me by repeatedly searching my crotch because she was vexed about not finding the cannabis. Philando Castile was murdered and shot to death in front of his daughter because of the smell of cannabis. In 2014, the Minnesota legislature botched the medical cannabis bill, establishing the most inequitable, restrictive, inaccessible, and expensive medical cannabis program in the country. Now that we appear to be close to legalizing cannabis for adult personal use, many of us whose lives will be impacted fear the legislature may ruin full legalization by producing a prohibition-like model that perpetuates criminalization and disenfranchisement of Minnesotans. That's not right. Minnesota has a unique opportunity to demonstrate for the country and the whole world what it looks like to truly begin to end the corrupt, failed, destructive, and structurally racist war on drugs. So please think big, act courageously, and do justice with full legalization of cannabis in Minnesota. These are low possession and purchase amounts. That's prohibition light.
Thank you for your testimony. Vina Iyer, and then Mason Alt on deck. Please introduce yourself and then proceed with your testimony.
Thank you. Vina Iyer of the Immigrant Law Center of Minnesota. We are here to raise several items of concern regarding the unintended negative consequences of the expunged provisions of HF 100 as currently drafted for non-citizen Minnesotans. Important piece of background. Under federal law, immigration officials can and do request that non-citizens provide all criminal records when applying for immigration benefits or defending deportation, even if the records have been expunged under state law. This includes naturalization, renewing work permits, and visas. With that background in mind, we would request the following changes. We support the provision requiring a good faith effort to inform individuals whose records are being automatically sealed or expunged that this is occurring, but the statute should require that the notice clarify that for non-citizen Minnesotans, expungement does not necessarily eliminate any potential immigration consequences, and that they should consult an immigration attorney. We also recommend that any notice provisions be sent to the last attorney of record. The current bill also explicitly states that records will not be made available to the subject of record. We believe the bill needs to be amended to include a relatively simple avenue for non-citizen Minnesotans to obtain expunged criminal records, such as including a provision that the subject can obtain a copy for good cause, including obtaining for immigration purposes. Next, we believe that the bill needs additional language clarifying the difference between referencing vacatures and expungements, vacatur being for convictions and expungement being for criminal records. And finally, that the bill should include provisions to make sure the public is informed that even if the use of cannabis is lawful at the state level, it is unlawful under federal law, and making sure that folks understand the consequences of that through public education. Thank you.
Thank you for your testimony. Mason Alt. All right. Doesn't look like Mason is here. So that wraps up folks who signed up ahead of time. At this time, I'll ask if there are any members of the public who did not already testify who would like to testify on this bill. All right. Thank you all for signing up ahead of time. With that, we'll move on. There is one non-author's amendment that will be before us. Representative Scott, I understand that's your amendment. Would you like to move it and then tell us about your amendment?
Thank you, Chair Becker-Finn. Yes, I'd like to move the A11 before the committee. And what this amendment does is it makes let me turn to page 40 so I can tell you the exact section here. This has to do with investigative data and whether or not it should be made public after the investigation is, after the data is not inactive, after the investigation is inactive. So it comes under trying to find the inspection and licensing section. And Representative Stephenson, thank you for the conversation yesterday evening. And I debated on whether to offer this amendment or not. And as I look through just a cursory amount of articles that I have on the fraud and different things that are happening, the corruption that's going on in other states with licensing, I really feel like, as was stated before, is that sunshine is the best disinfectant. This is a brand new multi-million-dollar industry that's being set up here by the government. And I believe that in order to keep Minnesota out of the headlines as much as possible, I think we need to have as much daylight as possible on this. So, and I'm willing to talk about the timing of when that investigative data, or that's when the investigation has been closed, the timing of letting that out. But one of the other factors that came into my mind as I was contemplating whether to do this amendment or not was, we all know that out on the internet, you can basically say anything horrible about a business that you want to. And so the argument that businesses would have a problem because anybody could bring an accusation, an investigation would open, and then possibly become, obviously inactive if there were no grounds for that investigation or alleged problem. A person that is disgruntled could put something out there on the internet anyway. So for those reasons, I'm going to offer this amendment and ask for as much daylight as we can get on this as it's set up. Thank you, Madam Chair.
All right, thank you, Representative Scott. Representative Stephenson, we'll go to you next.
Thank you, Madam Chair. Representative Scott. I'm going to lead with the headline, which is that I think I'll support the amendment. I think it's a close call. I really do. You kind of mentioned one of my concerns about this, which is if you have an investigation that's triggered by a really baseless allegation, it could be harmful. I think, we treat investigatory data in different ways in different aspects of the law. And there are some examples where this data would be private and some examples where it would be public in analogous fields. I think in the context of liquor, for example, and you and I talked about this yesterday, and likewise, I appreciate the good discussion that we had yesterday, that analogous data would be private in the liquor space. But I think your point is well taken that this is a new industry. I do want to say that because I think it's a close call, I think that this is something that we should probably continue to talk about and think about. The other concern that I have that we didn't talk about last night that I'm thinking about this morning is we want to make sure that this isn't an obstacle to businesses operating in Minnesota as we're trying to set up a new market. One of the places that, listening to testifiers talking about the importance of getting rid of the illicit marketplace, one of the obstacles in other states to that has been a regulatory or licensing atmosphere that is too cumbersome and hostile, and so businesses don't appear, and it creates more demand in the illicit marketplace. So it's just something to balance and think about. But like I said, I think it's a close call, and I'm persuaded by your argument today. So I'd ask the committee for a yes vote on this amendment.
Thank you. Any follow-up?
No, thank you for your support and conversation.
All right. Any further discussion to the A11? All right. All those in favor of the A11, please say aye.
Aye.
Aye. Opposed? The motion prevails and the amendment is adopted. Thank you for showing everybody how this is supposed to work with having the conversations and getting to a place where, we can make the bill better. And I think ultimately that's what we're trying to do. So thank you, Representative Scott. No more amendments in front of us, so we will move on to member discussion. I know we often limit the discussion on our bills to the things that are within our jurisdiction, but we'll recognize that this is a bill where there are a lot of sections that are within our jurisdiction, but would ask as much as we can if we can keep our discussion to the areas around data and civil liability and some of those things that are more. Representative Stephenson, how many committees is this bill set to go through?
I think we're up to 14. We've had to add one, so.
Cool.
And this is number 2.
So there will be plenty more times to improve the bill as it moves through the process. So with that, any discussion to the bill as amended? Representative Niska.
Thank you, Madam Chair, and thank you, Representative Stephenson. I am very interested in your thoughts about the Min-Koji letter and Mr. Neumeister's testimony. And I'm very concerned. I mean, I have a lot of concerns about this bill, as you and I have discussed. I think it's the wrong direction from a big picture policy perspective. But I'm very concerned about creating a new government agency that has essentially total power to define the market, define the licensing. And I appreciate that there are provisions in the bill that say that the scoring for how those licenses are given, that there has to be some disclosure about the standards. But the standards are very subjective, and whatever the scoring is going to be very subjective. And I'm very concerned about the potential for corruption and abuse in that process if we don't have some sunlight into how the office is applying those scores in specific cases as it decides who is allowed in the marketplace and who is not allowed in the marketplace through its licensing decisions. And so I would really like to hear your thoughts on I think that where Minkoji is drawing the lines on some of those things is probably the right place to draw the lines on some of those things so that we can have sunlight and a public ability to understand the way the office is actually applying those standards in the real world. And I'm interested in your thoughts on that.
Representative Stephenson.
Thank you, Madam Chair. Representative Niska. Yeah, I think it's a really important issue, and it's a hard issue. So, Minkoji in their letter raised 4 points. We've adopted now 2 of them, one in the author's amendment and one in Representative Scott's amendment. There's another one that I'm not willing to that isn't really responsive to what you're asking about. But, there's a whole lot that they were asking for in terms of changes in terms of public and private. And I asked for some clarification on that a couple days ago, received it yesterday. I'm still thinking a little bit about it. So let me tell you sort of generally my thought process is that I don't know that we should treat this industry extremely different from other regulated industries in the state of Minnesota. And my understanding is that the data classifications that are at work in this bill at present track what we do in other industries. There might be special reasons why in this particular case we should we should treat it differently, and I'm willing to consider those, but I don't know that we should have it wholly apart and entirely different rules. So I think that that's still something we're thinking about. This is something that Representative Scott and I talked about last night, that we're going to continue to talk about the data classifications in this with regard to that specific issue, and I'm open-minded and willing to have the conversation. But that's maybe my guiding principle is consistency.
Any follow-up, Representative Niska?
Thank you. I appreciate the comments. I guess I'll push on a couple of specific things, which are there are some kind of mushy standards in terms of, or that at least that could be mushy standards in terms of a diversity plan, in terms of social equity applicants, in terms of the labor peace agreement, and the way that the office in practice applies those and issues those scores, I think is going to be a very important piece of public information, not just how the office defines those standards generally, but how that actually plays out in who gets let into the market and who gets kept out of the market. So I hope that you will take seriously those suggestions if we do go down this road and pass this legislation, which it seems that that's what the majority wants to do. I do think that it's going to be very, very important that we place checks and some sunlight on this administrative agency and the power that it has and how that power can be reviewed by us, by the public, and potentially in the courts as well.
I've heard the word squishy before in committee, but I don't think I've heard the word mushy in committee, so thank you. Next on the list, I've got Representative Johnson.
Chair Becker-Finn, Representative Stevens, as you know, I have a lot of concerns on this bill and this direction that this is going. But I actually have a couple different questions. One is I need to have for Sheriff Torgerson, if he could come down to that, because he brought up an issue that.
And Representative Johnson, before we bring anybody up, since this is this is my committee, what is the issue that you're wanting to ask about? Because if it's related to public safety, you and I are both on public safety.
I am not on public safety. I don't
Oh, okay. Sorry about that. But if it's relevant to one of the other 13 committees, then it may be better off in one of those committees.
Okay.
So
he brought up the issue with the canines. With this bill, we're going to shut down our entire canine program across this state.
And that is not before the Judiciary Committee. I love dogs, and we can talk about this. I'm happy to talk to you before we get a crack at it in public safety. But, we're not going to go down the animal road here in the Judiciary Committee this morning.
Okay, I will stay away from that one, but I still would like to talk to Sheriff Torgerson afterwards, because this is a huge issue. It's going to cost our counties and cities depending on the size, number of dogs, it could cost some cities $50,000 to $60,000 to retire the dogs and get new dogs. That's what this bill does. Two other issues. One, you have Representative Stevens, you have the issue with the expungement. Have we found out the cost of what it's going to cost the judicial system to do all these expungements? Because that is in the purview of this committee. It's going to be a huge cost to the judicial system.
Representative Stephenson.
Madam Chair, Representative Johnson, the fiscal note for the bill this year is still in progress. There was, of course, a fiscal note for a very similar bill last year that I don't have in front of me at the moment, so I couldn't tell you what the cost attributed to the judicial branch was in that fiscal note. But I'm sure that that is available somewhere. And like I said, it hasn't been completed yet this year.
We can have folks look for it and make sure that we get that out to committee members. It shouldn't be that hard to pull up the fiscal note from last year.
There is an appropriation in the bill.
Oh, is John? Are you pulling it up? Mr. Walls.
Madam Chair, it'll take me just a minute here.
Okay. Did you have another issue, Representative Johnson? Otherwise, I can come back to you.
I can go on with that one because I'm hoping that, when it comes to time, this bill might have to come back to deal with that issue to this committee because it is part of this bill. And the other question I have for Representative Stevens is under federal law, funds from programs like this, the marijuana program, cannot go into our banking system. Now, if we have a convenience store that's selling, that gets a license and selling, and they're commingling their funds, how are they going to end up legally with the federal government getting those funds into the bank?
Representative Stevenson, that sounds like a commerce question, but I'll allow it.
It still deals.
I'll allow it, Representative Stevenson.
Thank you, Madam Chair. Representative Johnson, and one thing I should have mentioned on the last note, and maybe we'll return this in a second, the bill also includes obviously some revenue components. And so I think on net, the bill is not a net cost. It's a net revenue raiser. At least that's what I recall from the combination of the fiscal note and the revenue estimate from last biennium. So that's important to keep in mind. And I hope to only darken the doorstep of this committee once on this bill. You're all delightful, and I'll be here on many other bills, I'm sure, but on this one, maybe once.
Mr. Walls, any illuminating information?
Madam Chair, I'm still scrolling down to the section of the Supreme Court. It's a very long fiscal note, but the total request for the Supreme Court based on last year's bill was $1.1 million.
All right. Thank you, Mr. Walls. Representative Stevenson, any response to that?
No. As I mentioned, the bill is a net that contains a revenue element that is sufficient to.
Yeah, my understanding is that it pays for itself, or I don't want it coming out of my budget either. So.
Banking. I was trying to remember what your question was, Representative Johnson, Madam Chair. On the banking issues, number one, I think it'd be great if you join me in going to our federal representatives and asking them to rectify that issue. The banking community, I can tell you, if you've talked to them, would really like that, and they like it under existing Minnesota law to change because of the medical program. But on the expansion, that's an issue that they are eager to see resolved. It does present business challenges, federal laws there. Obviously, there's nothing that we here at the state level can do to control what the federal government decides to do on their rules and regulations. I will note that both on the medical and on the adult use side, in both Minnesota and other states, businesses have figured out a way to handle those problems. And I don't know that there's one specific solution that I'm going to articulate to you today in terms of how businesses do this, because I think it kind of depends on the specific situation. But it's a challenge. It certainly is a challenge, and I really wish the federal government would fix it.
All right. Moving on to Representative Finke.
Thank you, Chair. I also have a question about expungement. Hopefully we can move forward with. And I did try to find the answer to this beforehand, but. So in the expungement articles, we have automatic expungements for misdemeanors, and then we have the board, which will determine felony expungements. And I saw in the bill that the felony board will meet monthly. But my question is there a timeline for which felonies that should be expunged under this will be expunged under this? Because short of doing a blanket expungement, people could remain incarcerated or in positions of being felons for much longer than they should be. We recognizing that these felony convictions were wrong. They have, as we heard, highly racist past in which they have been executed. So it would be great if we could let those individuals know within a year, within how long will we spend doing these reviews while people wait to have their felonies overturned.
Representative Stephenson.
Madam Chair, Representative Finke, yeah, this is a really challenging task that we're asking the board to undertake. And I'm not sure it is practical to put a deadline on it because the reason why we're taking a board approach as opposed to an automatic approach is because there's a lot to be disentangled here from the combination of how our narcotics laws are structured, where you have, there's not a felony that's like cannabis possession or cannabis sale. It's 5th degree drug possession, to wit cannabis. It also could be to wit heroin, and you've got to sort through that. It could be combined with other counts, other charges. Some cases could involve a firearm. Some cases could involve violence. Some could not. So there's a lot to disentangle. In addition, you are potentially going through, not potentially, you are definitely going through decades of felony convictions, including for people who have exited completely the criminal justice system decades ago. I talked to someone just yesterday who was talking to me about his experience with this issue literally 50 years ago, right? So I'm not sure that there is a way that we can even now know how long it's going to take the board to get through all of that, nor do I think putting a deadline on that is a good idea, because I think that there's just, it's a big undertaking and they're going to have to take their time getting it done and to do it correctly.
Representative Finke, any follow-up?
I appreciate that, Representative Stephenson, and I'm very grateful for the work of expungement that this bill is doing. I'm so glad we're going to get to this, and I just want to make sure that we understand that the responsibility of righting wrongs is ours. It is not those who have been penalized unjustly in the past. So I hope that 5 people on this board are able to be judicious in their ability to do that work. Thank you.
Thank you. Now I've got Representative Frazier, and then hopefully we can move on to the vote. Representative Frazier.
Thank you,
Vice
Madam
Chair Frazier.
Thank you, Madam Chair. Representative Stevenson, thank you for carrying the bill this session, and I am very hopeful we will get this to the finish line and really correct some wrongs. I think you spoke to this earlier in your comments that our war on drugs has done more harm than it has done good, and I think we're recognizing that with the work we're doing in this bill. I'm standing in the lane of expungement. Thank you, Representative Finke, for raising that. My question is around, have you thought of adding an amendment that would deal with expunging evictions on those that have been evicted based on the fact that they had possession of cannabis?
Representative Stephenson.
Thank you, Madam Chair. Representative Frazier, I think that's an excellent point. Yes, we've thought about it. Yes, I do think that's necessary to do for the same reasons, and I think language is being developed by several members, and I would anticipate that we should go in that direction.
All right, well, maybe one of the next 12 stops, we can
You got time.
take care of that.
Appreciate you.
All right, thank you. So finally, Representative Scott.
Thank you, Chair Becker-Finn. A few more questions, Representative Stephenson. One of the things that is required in this bill is a statewide monitoring system, and it's in the bill it says we're to contract with an outside vendor for all of that. And as we've learned, obviously I just want to state it for the record, but anytime the state of Minnesota contracts with an outside entity for something like this, the data practices provisions apply to that contractor as well, as if they are the state of Minnesota. But one question I do have on that statewide monitoring system is, how is that data in that system classified? Because I don't see it in the bill.
Representative Stephenson.
Madam Chair, Representative Scott, I'm going to phone a friend and ask if Representative Johnson, Mr. Johnson or Mr. Hopkins would have an answer to that question.
All right, I think it's a data question, so we're going to go to Mr. Hopkins.
Madam Chair and members, so the information that would be going into the statewide monitoring system is not classified anywhere in the bill, so it would be public by default.
Representative Scott.
Thank you. Thank you, Mr. Hopkins and Chair Becker-Finn. So that's a piece that we need to figure out going forward here. I have a question on the civil penalties. And I don't know, this may end up being a question for Mr. Walls, but I'm wondering, is there anything in the fiscal note that was done last year that kind of gave an estimate on what we think the state of Minnesota might collect on those civil penalties, or if that's even a common practice in fiscal notes to assume that someone's going to break the law? I don't know the answer to that question. That's why I'm asking it.
Representative Stephenson.
Madam Chair, Representative Scott, that is a good question. I've carried other bills with civil penalties, and I'm trying to remember if I'm trying to stall to give Mr. Walls a chance to get to the right point of the fiscal note. But I've carried other bills with civil penalties, and I don't recall that being, an offset to revenue. But maybe in this bill, it is. As I said, the fiscal note for this year is still under process. But if Mr. Walls has more information, I'd defer to him.
Mr. Walls, phoning lots of friends.
It's good to have friends.
Madam Chair, Representative Scott, I'm not sure that I can answer that question quickly. There is money from the Department of Revenue that I believe is basically tax revenue. I'm not familiar with seeing any fiscal note that has ever shown administrative penalty collections, and those collections go directly into the general fund. MMB does not appear on the fiscal note for marijuana from last year, so I'm not sure who would be tracking those civil penalties. But I can look more thoroughly and get back to you.
Thank you.
Good question, Representative Scott.
Thank you. Thank you, Chair Becker-Finn. And Representative Stephenson, the reason I asked that question, or one of the reasons, is first of all, I didn't know the answer, which you're not supposed to do around this place, but I did anyway. But these penalties are pretty high. They're pretty steep. And so the second question I have related to that is, what if somebody has 50 pounds of cannabis and the fine is $1 million and they can't pay that? What sort of repercussions for breaking that law will this person have if they can't pay the $1 million?
Representative Stephenson.
Madam Chair, Representative Scott, yeah, that's not a entirely novel problem, right? I mean, there are many areas of law where we have civil penalties that aren't combined with criminal penalties, and sometimes somebody is assessed a penalty that is beyond their means to pay. I think that the bill contemplates, or a fundamental principle of the bill, is that cannabis, the criminal justice system has not been able to address the cannabis issue over the last several decades. And as someone who works in that system as a prosecutor, I can attest to that firsthand. If we could have used, as I think I said in another committee, if we could have used our criminal justice tools to solve these problems, we would have already done so. So we're trying a different approach in this bill, and it is conceivable that someone could be assessed a penalty that they cannot pay. I don't know that that means that there should be a criminal justice consequence instead.
Representative Scott.
Thank you, Chair Becker-Finn. Representative Stephenson, is there anything in this bill that would say if at a certain point you're just going to be shut down? Would the authorities have, in a case like that, if it's just a person, not an official licensed business, but a person doing this, could law enforcement come and just shut them down, take away all the plants, is that in the bill somewhere, Representative Stephenson?
Representative Stephenson.
Madam Chair, Representative Scott, and if I get this wrong, I hope Mr. Johnson will correct me, but what I think the way to think about this is the bill creates a legal marketplace that requires licenses and has limits. And I think you heard some testimony saying that they wish those limits were bigger. But there are still some criminal justice penalties for people who are operating outside of the legitimate marketplace. So if you have someone who's licensed and is breaking the licensing or the regulations, the rules, and they're assessed a criminal penalty, yes, at some point their license could be revoked, I think, and then they would be subject to the other parts of the bill that deal with that problem.
Final follow-up, Representative Scott.
Representative Stephenson, so my concern with these civil penalties, especially because they are really steep, is that we're just putting something in statute that's not going to be enforceable. And people are just going to ignore what these is outlined here in the bill for civil penalties. And I got to think that that's going to play into the black market and keep it alive and well. I'll end my questioning there, Madam Chair, but I would request of the committee that we lay this bill over. We still have a lot of discussion on the data pieces, which is our purview. And this bill, it's got 12 stops. I don't think it's started even having committee hearings in the Senate. And I don't know what the hurry is on something like this. So, Madam Chair, I just think there's a lot of work to do yet that would lie within this committee's purview. And so I would ask, I would move that the bill be laid over.
That's not not the plan. And I mean, we are in week 3, so I'm sure that the Senate is almost always behind us as far as getting their work done. And I do think, I mean, we want to have full hearings like this in all 14 of the committees that are that this bill touches. And I think the idea is we need to keep it moving so that those other committees and those other members can have a crack at Representative Stephenson, so we can keep it moving. So it would still be my motion that we move this to the Environment Committee. I appreciate your feedback, and I think I know that Representative Stephenson will remain open to having discussions and improving this bill just like any other bill that's before us. So that would be my intention, to move this to the Environment Committee as I moved at the beginning.
Chair Becker-Finn and Representative Stephenson, I guess I just would ask then that if these data provisions are worked on, if there's a willingness to bring the bill back to this committee to have it fully vetted, because I'm happy to work with you, Minkoji, others are happy to work with you, but the full committee should probably have knowledge of what went on in those deliberations, if you will. So is that something, Representative Stephenson, you would be open to, and Chair Becker-Finn?
Representative Stephenson.
Madam Chair, Representative Scott, as I mentioned at the beginning, I'm hoping that we have one stop for the 14 committees. I'm happy to keep talking. I think we can do these things in a very, my door is always open. I think you heard from multiple testifiers that I'm happy to have these conversations. And I promised you last night, I'll say it again on the record, that we will continue to work on this. And ultimately, the bill is going to come to the full House, where the members of this committee and all of the other members of the House will have the opportunity to debate and discuss what's happening. And everything's happening in an open way. Amendments are adopted at the beginning of committees. I think that we can have that process. I'm mindful of the concerns raised by this committee, and we'll continue talking about them. But it would be my hope and expectation that 14 committee stops and 14 different committees is maybe enough.
And, I think it's important for folks that this happens all the time with all kinds of bills where issues get brought up. We talk about them in public, in committee, and there isn't time to write an amendment on the spot, but maybe out of the discussion, we all have ideas, and ultimately we do all get another crack at it because it will be on, assuming that it makes it through all those 14 stops. But I mean, it is not out of or if I pulled back every single bill that got better after our discussions here, we would be here even more than we already are. So it would also be my intention to only have this here this one time, but we all serve on multiple committees. I bet you will each have at least one more shot at this bill in committee as well. Representative Stephenson.
And Madam Chair, Representative Niska's already had it twice.
I will not see it again.
Well, I hope you will on the floor. And to that point exactly, in the Commerce Committee, there were changes that were made today and discussed that were within the jurisdiction of the Commerce Committee. The Commerce Committee heard the bill last week. The bill is not probably going to go back to the Commerce Committee either. That's very common, not just for this bill and other bills. So I'm not proposing that we do anything out of the ordinary, and you have my ironclad commitment to continue to work with you on this issue, Representative Scott.
All right, final follow-up, Representative Scott.
Thank you, Chair Becker-Finn and Representative Stephenson. I do want to point out that we've had 2 bills leave this committee and then come back already. This is a 300-page bill, and there are a lot of data provisions in this bill. And we've already discussed that it's a very limited number of legislators that have any interest at all in Chapter 13, let alone really understand it like the committee members here do. And so I just hope that if there's a need, that there will be an openness to move it back to this committee so that, for one thing, it educates the other members of this committee on good governance as the bill moves along. So thank you, Madam Chair.
Thank you. And I will say, for the record, there's only one bill that came back, and it was House File 4. I chose to lay over the Jordan bill. I made that call as the chair, and I'm making this call as the chair. So I will renew my motion that House File 100, as amended, be recommended to be referred to the Environment and Natural Resources, Finance and Policy Committee. All those in favor, please say aye. Aye. Opposed?
No.
The motion prevails. The bill is on its way. I don't want to keep you guys late, but Representative Stephenson, we're going to move right to House File 6. I will move that House File 6 be recommended to be placed on the general register. Let's see. You do have, this is an author's amendment, correct? Representative Stephenson? All right. I will move the A4 amendment in front of the committee. Representative Stephenson, please tell us about the A4.
Madam Chair, members of the committee, very briefly, this amendment incorporates some feedback that we received in the last committee relating to the ability of the governor to shorten the period of time that the price gouging restrictions are effective if there's an emergency.
Great. Any discussion to the A4? All those in favor of the A4, please say aye. Aye. Opposed? The motion prevails. The amendment is adopted. Representative Stephenson, please tell us about House File 6 as amended.
And Madam Chair, members of the committee, I'll be very brief on this in recognition of the time. This is the price gouging bill. It establishes in statute protections against price gouging in the occurrence of an emergency. The bill is in front of this committee due to the civil penalties. Members who were returning from last year will recall that we had a good discussion about the civil penalties on the floor when this bill came.
If members of the public could take their conversations outside of this room, that would be great. Thank you. Back to you, Representative Stephenson. Sorry about that.
And so we are here to talk, I think, primarily talk about the civil penalty aspect of this provision.
All right, sounds good. We didn't have any public testifiers sign up ahead of time, but are there any members of the public wishing to testify on House File 6? Doesn't look like we've got anybody wanting to testify on House File 6, so we will move on to member discussion. Members, any discussion to House File 6? Representative Niska.
Thank you, Madam Chair. Thank you, Representative Stephenson. I hadn't noticed until we had a new engrossment that the amendment in Commerce deleted any references to Section 8.31 as it relates to the Attorney General's enforcement power. And an earlier version had referenced Section 8.31. And I appreciate the clarity that this version does not have a private right of action, which is an important step, I believe, in the right direction. But I'm curious about what are the procedural provisions then that apply to the Attorney General's enforcement of this? And then secondary question, maybe we can follow up on this. I'm curious about how the data, or maybe you can phone a friend on this question, how the data
Representative Niska, I'm going to have him answer that question because I know I have trouble remembering multiple questions. I will definitely get back to you for the second one. Representative Stephenson.
Thank you, Madam Chair. Representative Niska, I think subdivision 6 and 5 of the bill kind of articulate that violations of this section can be investigated and that the Attorney General can bring a civil action subject to the civil penalties in subdivision 5. So I imagine that it would proceed in that manner through the courts. I don't know if that is what you were looking for.
Representative
We tried to narrow the scope. I'm sorry to keep going, but we tried to narrow the scope to make clear that this statute and this statute alone controls what penalties are available.
Representative Niska.
Thank you, Representative Stephenson. 8.31 does have some procedural, more articulated procedural scheme for Attorney General enforcement, and so that's really what I was asking about. This provision doesn't reference that at all, and so that's a concern, is that it may be a little bit more, what was the word, mushy? I can't remember what word I used before. So that's the concern I have with that it's good that 8.31 just isn't an open-ended reference as it was in an earlier version of this, because that would incorporate a private right of action. but I'm a little concerned that this doesn't define the procedure very well. So take that for what it's worth. I understand your answer to my question. If I can proceed to the other question, Madam Chair. The other question, and this is, I don't mean this as a gotcha question. This might be a question for research, but I was just curious if someone could help us understand. We had talked about the inactive investigative data in House File 100. What is the government data status of an investigation under this provision that becomes inactive? If anyone knows the answer to that.
Actually,
Representative Stephenson, do you know this one?
I'm going to try, because we'll see if I learned anything from the emails I got from Mr. Hopkins about the last bill, which is I understand that investigatory data that relates to a civil investigation is presumptively public once it's inactive. It was the licensing data that was presumptively not public. And so I think it's public data. But Mr. Hopkins,
Representative Stephenson, Mr. Hopkins is nodding. So you learned something. Good job.
Really proud.
Good job. Any follow-up, Representative Niska? We all maybe learned something. Thank you, Nathan.
No, I just as a policy matter, I'll reiterate the concern I shared with you in Commerce, which is the types of abnormal market disruptions we are talking about are situations in which private actors, businesses, and individuals have to make extraordinary efforts to get essential goods and services to the market. And as an attorney potentially advising one of those individuals or businesses under this provision or where an abnormal market disruption has occurred, I would likely caution them about even participating in the market at all, which I think is a worse outcome. Empty shelves are much worse than high prices for essential goods and services. So just reiterate that more general policy concern about the bill. I think it's the wrong direction, although I do appreciate that you have improved the bill, I believe, from my perspective, since it in the drafting process.
Mr. Hopkins has some nuance for us, maybe.
Oh, no.
Madam Chair, members, no. Representative Stephenson was exactly right. Under 13.39, which deals with civil investigation data, inactive civil investigation data is public. But there's also a section that, and Representative Stephenson made this point earlier as well, that inactive investigative data gets treated differently in different sections of law. In the Attorney General section, 13.65, investigative data that's inactive is classified as private data on individuals. So the Attorney General can decide whether or not to move something into 13.39 as civil investigation data, and when it becomes inactive, it would be made public, or they can keep it in 13.65, the Attorney General's own data section, where inactive investigative data would be classified as private. So private or public, depending on
members, you weren't here before Representative Stephenson, but I think Representative Scott's suggestion to folks that you can get Chapter 13 in your own little book might be really great advice for all of us. Final follow-up, Representative
I have one last comment as it relates to Mr. Hopkins' point, which is that I personally agree with the dissent of Justice Thiessen in Energy Policy Advocates, and would love anyone across the aisle who's interested in fixing that statutory interpretation question and returning data on individuals under the 13.65 to actually being limited to data on individuals. I would love to work on that with anyone.
All right, thank you.
I apologize for my not totally germane comment, but in reference to what Mr. Hopkins said.
It's okay. We all learned something, and there's no problem with that. Representative Johnson.
Chair Beckerfin, Representative Stephenson, I understand why you're looking at doing this, and I do have some problems with the bill and how it works. It can actually hurt, especially small businesses and mom and pop shops that are trying to survive in hard times. I don't think there's a few people that remember the December 31st, 1999, going into January 1st, 2000. All our computers were going to crash. Everything was going to just go up in flames, and nothing was going to work. in my community, we happen to have a gas station owner, the only one at the time that was open 24 hours, decide to jack the prices of his fuel. It went from $1.53 to, at one point, it was over $8 a gallon. And the price was changing while people were pumping into their tanks. A month later, that business was out of business because the people stood up because they knew he was doing what happened. And the open market fixed it. Everybody quit going there. I don't think we need to do this. I think there's a lot of good things that people do. The bad actors, what comes around goes around. And the people, if a business is gouging, people are going to stop doing the business there. You might not agree with me, but that's how it works. That's how it works in my community. That place is shut down after, and it took multiple years and multiple people, different owners, trying to get it started again before it came back. And it just came back last year to an open business that's actually functional again.
Thank you.
So I don't think we need to do something like this. I think we need to let the market work and let the people in their community deal with it.
All right, thank you for your comment. Representative Scott.
Chair Becker Finn and Representative Stephenson, I just have one question. So under your bill, could the Attorney General shut down a business then?
Representative Stephenson.
Madam Chair, Representative Scott, under this bill, the only penalty is described in subdivision 5, which is a civil penalty. That civil penalty, and in fact, it in line 2.27 of the last engrossed version, and I believe this language is still in the bill after the author's amendment, says no other penalties may be imposed for the same conduct regulated under this section. So I do not believe that this gives injunctive authority, if that is your question. As you discussed in the last bill, civil penalties can have consequences, and it kind of depends on your ability to pay. I think the amounts in here are not, probably rising to that level. I guess it probably depends on the business. But the only penalty is the civil penalty.
Thank you.
All right. With that, members, we'll move on to the vote. So I'll renew my motion that House File 6, as amended, be recommended to be placed on the general register. All those in favor, please say aye. Aye. Opposed? No. The motion prevails. Thank you, everyone, for Representative Stephenson Day here in the Judiciary Committee. We won't be coming back, and with that, we're adjourned.